Shambri. Yeah,
Thank you very much. I shall now say a few words about the procedure and the overall form of the inquiry. When I have concluded my opening remarks, I will invite the appellant, the counsel and RiverOak each to make brief opening statements which should be no longer than 20 minutes. I appreciate that the counsel does not wish to present formal evidence to the inquiry, but it would be helpful nonetheless if the counsel would make a brief statement explaining its current position. These opening statements will help everyone understand the main arguments. After the opening statements, I think it would be helpful to hear from any third parties who wish to speak. As I say, I've had two people that have indicated that they wish to speak this morning. So it's subject to the agreement of the advocates. I think it might be useful to hear those people first, after the opening statement. Now, in terms of the order of evidence, normally the counsel would present their case and evidence first. But obviously in this instance the counsel is not contesting the appeal, so the main party opposing the appeals is RiverOak. Therefore I shall hear their evidence first, so everyone can hear the objection. The appellant's advocate will then have the opportunity to cross-examine RiverOak's witnesses, and then RiverOak's advocate may then put some questions in the examination. There will be an opportunity for questions, and I may have some questions in my turn. If there is anyone else who is opposing the proposals who hasn't already spoken, we may then hear from those people, as I say, but if they haven't already spoken. And as I said earlier, those who give evidence may be expected to answer questions on their evidence from the appellant's advocate, and I may also have questions as well. Then I will, after that, I will hear from the appellant. I will ask them to present their evidence in the same way, namely their case and evidence. Then RiverOak will have the opportunity to cross-examine the appellant's witnesses, the witness in this case, and the witness will then be re-examined by the appellant's advocate. After that, it may be the case that we hear from anyone else supporting the proposals if they have not already spoken. As I said, those who give evidence will also be expected to answer questions on their evidence from the advocates, and I may also have questions. I have had also a request from Sir Roger Gale, I should say at this point, who's the MP. Unfortunately, he said he couldn't be here today, but he is available on Thursday, and I did indicate that we would try and slot him in on Thursday morning. Right. In terms of after we've been through all of that, we will then discuss conditions where I'm minded to allow the appeal. This is a normal part of the proceedings, and it doesn't mean I've made up my mind about the appeals or prejudged them. I haven't. It's simply an opportunity for us to deal with the conditions whilst everyone is here, and a schedule of conditions has been provided to them, and this will be the basis of our discussion. In terms of the Section 106 agreement, I'm not aware of any being put forward. No. I should also mention costs as well, that if anyone is proposing to make an application for costs, that should be made before the close of the inquiry. I haven't received any cost applications, and I'm not encouraging or inviting any cost applications, but as I say, if anyone does envisage making a costs, please let me know before the close of the inquiry. I also have the power to initiate costs if I feel the behaviour of either party or any of the parties is unreasonable and has led to unnecessary expense. After that, I will hear closing submissions from the main parties. If the council wishes to make any concluding remarks, I'm happy to hear those. Then RiverOak, and then finally the the appellants, they always have the last word. The closing submission should be in writing. That is most helpful if they can be in writing. In terms of the site visit arrangements, I have already made a preliminary visit to the site, and I have seen it from various public viewpoints, but I haven't actually entered the site itself. I shall be making an accompanying formal inspection of the site, and I will need to be accompanied by all the main parties, including the council. Other parties may also attend, but this is subject to the agreement of the landowner. I should stress that the site visit is solely for me to see the site and its surroundings in the light of the evidence that has been put before me. There will be no discussion on the site itself about the merits of these appeals, or will evidence or submissions be given on site. So any points that people wish to make should be raised here in this room and not on the site visit. I would expect the site visit to take place towards the end of the week, but it may be brought forward depending on what progress we make and indeed the weather forecast as well. Now, in terms of, there doesn't seem to be a witness table. So, oh, there's one there. Right, okay. That's the witness table at the end. I'm rather unfortunate that I can push it forward, is it? No, I was thinking more that the people aren't going to face the members of the public.
One of the top tables could be used for recruitment, but obviously then that's behind yourself.
I don't think that's a very good idea. I think, I don't know if there's any way around that, to be honest. I would prefer it if members of the public were able to see the faces of the witnesses, but we'll have to look at that in due course. Right. It's usual practice for the advocates to sit, but I'm happy for them to stand if they feel that it would aid all the visibility. I don't know what your views are. I'm happy either way.
Yes, yes. I'd have leapt at that offer a few years ago, but now I think I'm quite happy to sit. So.
Well, that's fine. As long as everyone can see the main components, as it were, that's fine. I just wondered also whether we were able to leave material here overnight. That was the other question. Perhaps the council can answer that.
Apologies, I was just trying to work out how to sort out the witness table. Could you repeat the question?
Sorry, I was just wondering whether we can leave material here overnight.
Yes, we can. There is an evening meeting of the planning committee on Wednesday, and so what we will do is we'll make arrangements to shift the documentation on for either side to the edges of the room, and they will be observed at all times at that meeting. But yes, the documentation can be left here overnight.
Thank you very much, Mr. Livingston. Now, in terms of time estimates, the inquiry is scheduled for 4 days. Now, I'm hoping that will be ample time. Indeed, the 4 days was based on the fact that the council would be presenting evidence as well. So I would hope, in a way, that we may not need the full 4 days. I don't know whether the advocates have any views on that.
Yes, I do. I agree with you, Sarah. I think on the time estimates that you've been provided with, hopefully we should be through by Thursday.
Good.
I agree.
Good. Excellent. Thank you very much. Right, well, I will normally start each day at 10 o'clock, as today, but that time can be adjusted if necessary, and we need to start earlier, we will. I will hope to finish around 5 o'clock each day. We may run till 5:30, and I also plan to take short breaks during the morning and afternoon with around an hour each day for lunch. But as I say, these are not fixed and they can be adjusted according to the circumstances. Now, I need to establish a programme today to ensure that the inquiry runs efficiently. Now, I'm aware that both parties have indeed provided time estimates already, and I appreciate that these are only time estimates, but I wondered perhaps if you could update me on that.
total.
For cross-examination.
Yeah.
For all of them.
Yeah.
For all the cross-examination.
Yes.
It might.
Of the appellant's witnesses. Mr. Alston, I said, well, Mr. Alston's late in the week. I don't know if I said 30 minutes in cheap. It might be 40, but it's not going to be significantly in excess of that. My opening class would be very short.
Okay. That's very helpful, Mr. King.
Oh, I'm so sorry.
This Albany, perhaps you could.
Yes, indeed, sir. Our time estimates remain as provided to you. So that's 3 hours for all witnesses, save Dr. Dixon, where I think we've suggested an hour and a half. But we'll be within that. Miss Murphy will be calling Dr. Dixon, I will be calling the other 3 witnesses. So we're hopefully going to remain within the time estimates. For the organisation of your timetable, it might be helpful if Mr. King breaks down the cross-examination of each witness in terms of time estimates, and then we can perhaps programme how long we're going to be with each witness, and so we can programme where we're likely to get to today. That might be a helpful way forward.
Yes, Mr. King, do you have any comment on that point in terms of each witness?
Yes, I can do that.
With certain people?
Kane, none. Dr. Dixon, none. Mr. Yerrell, about an hour, or for an hour and a quarter, and Miss Shembley, about an hour and a half to an hour and 3/4. I mean, the split of the 3 hours is between Mr. Yerrell and Miss Shembley, and Miss Shembley's got most of it, so if that helps.
Yeah, that does. I mean, I'm not proposing to fix some very rigid timetable at all. I think it was just to get some idea as to how quickly we may progress, and I think there's a reasonable chance that we will be done in 3 days with any luck. Right. Well, that's very helpful. Thank you for that. I appreciate also that these are only time estimates, and they may vary. In terms of the plans that I shall be considering, I don't propose to list all these now because they were numerous, but I have been provided with an agreed list that was within the Statement of Common Ground, and they're listed at section 7. Can I take it that those are the correct plans? Yes.
So yes, it seems very helpful that it's listed there. So yes.
Have you got the signed statement of common ground?
I have. I've been provided with a I think I got it yesterday, which is dated the 10th of March. That was the most recent one I have, signed by GVA and Mr. Livingston.
Yeah, that's right. I just want to make sure it got through to you.
Yes, indeed. Thank you, Mr. King. Yeah, I do have that. And as I say, there is at section 7 of that document a list of the plans, which is what I assume are the plans that I should be considering.
Yeah.
Obviously, the council didn't actually determine 3 of the applications. Normally, you have a decision notice with the plans listed, but in this instance, we don't have the 3 of the applications. I also have a statement of common. That is the statement of common ground, which is very helpful indeed. It also clarifies a question that I had on the descriptions of the development. In other words, whether the appeals for the changes of use are proceeding on the basis of a flexible use or a single use class. The way the council described the applications varied from what was actually described on the planning application form, and I gather now that the council is content for the appeals to proceed on the basis of the original planning application description.
That is correct. I think that's in the statement. That is quite correct.
Yes, thank you.
And that's how we would like the appeals to be considered by you.
Indeed. And as I say, that does seem to be in the statement of common ground. Yeah. I mean, perhaps Mr. Livingston can confirm that he's happy with that.
Yes, I can confirm that. It was also in the appeal statement produced in February last year as well.
Yes. Thank you, Mr. Livingston. I've also, as I say, been provided with a schedule of conditions. We will use that as a basis for our appeal, our discussion on conditions. On a general point, all the documents and evidence should have already been provided in accordance with the inquiry rules timetable, but if any party wishes to submit any further documents, please be necessary to adjourn to allow me to read these documents and also for others to read the documents, and there may be a consequent risk of costs. So yes, you've got your hand up.
On the matter of document submission, I've submitted to you this morning four photographs, 4 copies of each,
Yes.
as requested,
Right.
and there should be some overheads, but I don't think that's probably got through in time.
Right. Well, when you speak, sir, we can. These are the documents you provided.
That is correct.
I will ensure that everyone has copies when I call you to speak.
Thank you.
Thank you very much. In terms of the main issues, I've obviously read all the submitted documents and the letters, and I had previously put forward a number of issues as I saw it, and at this stage, and without prejudice to the ultimate determination of these appeals, I consider the main issues to be whether the use of the buildings for non-airport related use is acceptable having regard to local and national policy. Secondly, whether the proposals would compromise the future aviation use of the airport. Thirdly, whether the proposals would create additional need for buildings in the countryside were airport operations to resume, and whether alternative employment land exists elsewhere. Now, as I say, this is without prejudice to the determination of these appeals, and these main issues may alter in the light of the evidence I hear, and also in the light of comments made, as it were. Another issue I did raise was the issue of the compulsory purchase order or development consent order as a way of reopening the airport, but I should make it absolutely clear that that is a separate procedure. I am concerned with the 4 planning appeals that have been locked. That is what I'm here to determine. I'm not here to determine the issue of the compulsory purchase order or indeed the development consent order. Those are entirely separate procedures. I need to make that absolutely clear to everybody. So my evidence needs to be focused on the planning applications rather than that's my prime area, as it were. Does anyone have any comments on the main issues? Mr. King, shall I ask you first?
No, I'm happy. That's what you said before, and that very much accords with particularly the last point, which I'm about to say.
Yes. Ms. Orsley, do you have any comments to make on that?
No, sir. Thank you for providing them to us in advance. It's all very helpful. Thank you.
No problem. Thank you all for that. Well, that concludes my opening remarks. Are there any other questions at this stage? Anybody have at all? In which case, I will ask the appellant to make their opening statement. Mr. King.
Thank you very much. I've got a short written opening,
Yes.
which I'll have distributed. I don't have a huge number of copies, but people aren't usually desperate to have a written copy. And we can make more, but people will hear what I'm going to say anyway.
Okay, Mr. King.
All right, thank you very much. These appeals, so as you told us all, concern proposals for the reuse of, and in one case a modest extension to, 4 existing buildings at the former Manston airfield. The appellants say that allowing the reuse of these buildings whilst the overall future of the site as a whole is resolved is entirely sensible and ought to be uncontroversial. There is now, again, so as you said, no objection to the proposals from the local planning authority, nor indeed from the county planning authority. The only real question, we say, is whether the future reuse or redevelopment of the site as a whole would be materially prejudiced if the appeals were allowed. Now, so the appellants have themselves made a planning application establish a predominantly cargo-based aviation use of the site. RiverOak now say that development consent rather than planning permission is required because the proposal is to use the site for more than 10,000 cargo air transport movements ATMs per year. It seems that at an earlier stage, RiverOak had in mind that they make a planning application rather than a DCO application, or perhaps considered that no such permission or consent was required at all, because they made two unsuccessful attempts to persuade Thanet District Council to enter into an indemnity agreement with them as a prelude to the council making a compulsory purchase order in their favour to facilitate the reuse of the site for aviation purposes. If the DCO procedure is followed, then in effect the cooperation of the district council isn't required. The land, of course, is owned by the appellants, that is the whole of the former airfield and the appeal buildings, but RiverOak don't have any interest in it in a legal sense, obviously, at all. Therefore, if RiverOak wishes to develop the site for its own purposes, it will have to include the appellant's land interest in the site in its application for development consent, and will have to seek the confirmation of compulsory powers in that respect. The development consent order regime, of course, allows them to do this, but in order to succeed, they will have to demonstrate that there is a compelling case in the public interest to justify conferring powers of compulsory acquisition on them, and will have to show that the public benefits which their project will bring will clearly outweigh the interference with the appellant's human rights that are protected under Article 1 of the First Protocol to the European Convention for the Protection of Human Rights. And so in assessing whether such a case exists, and this isn't you, this is the future decision maker, we'll have to take into account, alongside a range of other matters, the alternative proposals that the appellants have for their land, and whether these are equally, more or less in the public interest than RiverOak's own proposals. And those other matters that the DCO decision maker will have to take into account would also include whether RiverOak's project is financially viable and has in place the necessary funding to ensure that it is likely to proceed if the development consent order is made, whether any financial viability appraisal is founded on realistic assumptions or forecasts about, for example, the likely levels of demand for freight traffic, whether the project is acceptable in planning terms of such matters as obviously surface access, air noise and effects on protected species and habitats, and what conditions or other restrictions may be required to make the project acceptable, excuse me, and what effect these would have on the ability of the airport to operate as envisaged in the application. Now, so given the stage that has now been reached by RiverOak in the promotion of their project, although much, it seems, does remain to be done before an application can be made, that's still some months off, the appellants accept that RiverOak intend to make a DCO application at some point at the later stages during the summer, and that it is possible, of course, that development consent may be granted at the end of the necessary statutory process. And I emphasise that that it's accepted that it's possible that development consent may be granted, not that it will be granted, not that it will not be granted, not that it is likely or is not likely to be granted, but it may be granted in the sense that that outcome cannot, on present information, be ruled out. The appellant's own planning application, that is for the development of the whole site, is at a rather more advanced stage than RiverOak's intended DCO application, but some further information, as I understand it, remains to be submitted, and the application obviously, as you know, hasn't yet been determined. Equally, therefore, the outcome of that process is not known. Planning permission may be granted, but it may not be. Turning to the policies of the development plan, which is the Thanet Local Plan of 2006 that apply to Kent International Airport, those policies were written and came into force at a time when the site was still an operational airport. They are therefore couched in terms that we submit are plainly out out of date. The local plan expired in 2011 and the airport closed. Therefore, whilst some weight still attaches to those policies, that's entirely accepted, the weight must be limited because of those essential and incontrovertible facts. So far as emerging development plan policy is concerned, this, as it now stands, favours the comprehensive redevelopment of the former Manston airfield as a mixed-use settlement with at least 2,500 new dwellings and up to 85,000 square metres, say, of employment and leisure floor space. Whilst that is at an early stage in its statutory process, we submit it should attract some limited weight. Part of the evidence base for the emerging local plan policy about Manston is a report by Avia Solutions, which the Council commissioned, and which has concluded that airport operators at Manston are very unlikely to be financially viable in the longer term and almost certainly not possible in the period to 2031. RiverOak contest this, hardly surprising, and they've submitted evidence to the inquiry in an attempt to demonstrate that the conclusions that Avia Solutions have reached is wrong. However, so plainly, this is not the forum in which this dispute can or should be resolved. That, amongst no doubt many other issues, must be resolved through the local plan process in which the appellants and RiverOak intend, as I understand it, actively to participate. And in our submission, this is actually a very important point in the context of these appeals, and it applies to more than just the local plan. Given the range of issues which will fall for determination during the processes relating both to the appellant's comprehensive redevelopment application and RiverOak's forthcoming DCO application on the assumption that it's made, you, sir, plainly, we submit, cannot reach any considered and concluded view on the likely outcome of those processes, let alone each of the issues arising within them is likely to be decided. But we respectfully submit that the point goes somewhat further than that. You not only can you not reach any considered view on those matters, you should not do so and should not attempt to do so, because it would be likely to cause prejudice to the parties, that is both RiverOak and the appellants, the parties' positions as their respective applications have progressed. But in particular, we submit to the appellant's position as landowner, in respect of which RiverOak will have to show a compelling case in the public interest to justify the inclusion of compulsory powers in the DCO. We also submit it's not necessary for you to resolve or to speculate on those matters. You can't, you shouldn't, and you don't need to. The position we think is quite straightforward, as I've already indicated. The former airport's closed down, and there are two rival proposals, one by the landowner and one not, for alternative developments of the site. One involves the resumption of an aviation use, the other does not. The emerging local plan favours the landowner's scheme, but it is at an early stage, as I've said. These matters will be resolved through the forthcoming local plan planning and DCO processes, during the course of which the site owner, the appellant, and the promoter of the aviation scheme, RiverOak, along with the local authorities, Thanet and Kent, and any other interested parties, will be able to put forward evidence in support of their respective positions. And this inquiry concerns not the merits of the emerging local plan policy, nor the merits of the landowners and the RiverOak's respective proposals for the wider site, but it concerns the question of whether decisions about the future of the site are likely to be prejudiced if four of the existing buildings on the site are allowed to be reused for commercial purposes, in effect pending those wider decisions. And we say the answer is quite plainly that those decisions are not likely to be prejudiced if the appeals are allowed. So far as RiverOak's proposals are concerned, they've made it clear that in order for their scheme to be delivered, it will be necessary for them to acquire all of the land, including the appeal buildings that lies in the appellant's ownership. Since the appellants are unwilling to sell, this will have to be done, as I've mentioned, through the conferment and exercise nor in our submission is there any evidence of any other kind of potential prejudice to RiverOak's emerging proposals if the appeals are allowed. In those circumstances, if the appeals are allowed, if RiverOak's project is consented and proceeds, the compensation payable to the appellants is unlikely to be much, if any, different, and as RiverOak now explicitly accepts, wouldn't materially affect the viability of the scheme. There would be no significant, let alone insuperable, safety or security issues, even if the buildings were to remain in non-airport use, which is not, in any case, what RiverOak proposed. This is actually a complete answer to any suggestion to be any prejudice to RiverOak's emerging proposal. The Civil Aviation Authority were in fact consulted on the appeal application and raised no objection or any other concern, and there is no reason why possession of the appeal buildings along with the rest of the site couldn't be achieved following the exercise of compulsory powers within the same time scale. And so allowing the appeals would also be compatible with the appellant's own redevelopment proposals for the site should they receive planning permission and proceed. Finally, the appeal proposals would also bring some economic benefit to an area where unemployment rates are high by providing accommodation of a type which is in demand in the area. Whilst unsurprisingly, given the passage of time, the occupiers that the appellants had in mind at the time the applications were made have had their requirements satisfied elsewhere. Others are likely to take their place. The reuse of these four buildings has the potential to create around 300 jobs for local people, and we will submit that it's clear that the appeals, all four of them, should be allowed.
Thank you very much, Mr. King, for that. I just wondered, before we come to RiverOak, I was going to ask the council to set out its position. Mr. Livingston, you were just going to set out your position in terms of these appeals. I appreciate you're not proposing to give any formal evidence, but normally you would follow.
Yes. We have a statement which will be circulated, which has already been sent to you as well, which outlines our position. So I'll read from that statement if that helps.
Has this been provided to?
It's just to be provided. It was provided yesterday as your clerk effectively requested it, and now it's being provided to both sides, so nobody has a copy of it.
Right. Apparently, I don't know, Mr. King, have you seen?
No,
No.
I haven't seen it before.
No one would have seen this statement.
Right. Are you happy for Mr. Yes. It's just really to set out the council's position. Hopefully there'll be nothing surprising. I'm sure there won't be. Right. Mr. Paulson.
In October 2015, the Planning Committee considered, that's the Council's Planning Committee, considered the planning application for the change of use of Building 870, referred to as Building 2, Spitfire Way, Manston Airport, from airport use to general industrial use, together with a 4-storey extension and insertion of windows under planning reference F/TH/15/0457, and refused the application for the following reason: that the proposed development, by virtue of the loss of a building for aviation use, would create the potential need for additional buildings within the countryside and would not constitute essential airside development, contrary to Thanet Local Plan Policies CC1 and EC4 of the Thanet Local Plan, and paragraphs 14 and 17 and guidance within the National Planning Policy Framework. On the 16th of February 2016, the committee outlined that they would have refused the other 3 planning applications the subject of this inquiry for the same reason for refusal. Prior to this, in December 2015, the Council's Cabinet sought to set out a formal process for identifying interest from third parties to be a council indemnity partner for a potential compulsory purchase order CPO for Manston Airport, with a view to secure its future operation as an airport. The Council then submitted its statement of appeal in February 2016, which stated the planning position at that time. Subsequently, in June 2016, the Cabinet of the Council considered a report dealing with the CPO. This report outlined the process, calling for expressions of interest to be council indemnity partner for a potential CPO for Manston Airport, and required that partner, following the acquisition of the site, to make a significant investment with a long-term business plan to deliver a viable and sustainable airport operation. The assessment of those expressions were based on 4 key lines of inquiry: assessing capability of the marketplace to deliver the requirements, assessing whether or not there is an established market to deliver and an adequate number of operators, assessing the capacity of the market to deliver the requirements, and assessing the feasibility and cost viability of any proposed action going forward. The assessment drew the conclusions that the market could not deliver the Council's requirements for a CPO, there being no established market or an adequate number of operators able to deliver an operating airport. It concluded that there were no costs or other benefits in taking the matter further. The Cabinet noted the results of the soft market testing assessment and decided to take no further action. Subsequent to this, an independent study was commissioned from Avios Solutions into the viability of airport operations at Manston as part of the local plan process as a means of dealing with the future of the site. Avios Solutions reported in September 2016 and concluded that airport operations at Manston are very unlikely to be financially viable in the longer term and almost certainly not possible in the period to 2031. This conclusion was based on an assessment of future air traffic demand. Even applying assumptions favourable to Manston Airport, the report concluded that it is most unlikely that Manston Airport would attract private investors nor represent a viable investment opportunity either during the local plan period to 2031 or the longer term after 2040. Therefore, in the Council's view, there is insufficient evidence to justify a policy that seeks to retain the airport site for a period of the emerging local plan. Indeed, given the findings of the report, it is clear that there is little, if any, evidence to support the retention of policy EC4 or its objectives, and the Council is of the view in this respect that it is now outdated by reason of the change in economic and market circumstances in the air industry. It follows that there is insufficient evidential justification currently to warrant full or substantial weight being attached to policy EC4. Moreover, paragraph 22 of the MPPF requires applications to be treated on their own merits, having regard to market signals and the relative need for different land uses to support sustainable local communities. The direction of the draft local plan, although in its comparatively early stages, is to allocate the site for a mixed-use development, and the 4 applications the subject of these appeals would be consistent with this new direction. The proposed uses of the buildings would generate employment, would reuse vacant buildings, and are well connected to the existing road network. Given the change in circumstances occasioned by the Council's assessment of the prospective viability of Manston as a functioning airport, and given the fact that the premise of policy EC4 is now substantially in doubt, thereby affecting the weight to be attributed to it, and weighing the benefits of the proposals against any harm to the countryside when applying policy CC1 of the current local plan, it was considered by the Council that the grounds for refusal on the appeals could not reasonably be sustained. The Council has consequently decided not to pursue its objections to the proposals for the purposes of these appeals, and the Council therefore raises no opposition to the appeals, subject to the imposition of appropriate safeguarding conditions. In taking this action, the Council considers that it has acted both responsibly and reasonably in response to the changed circumstances and the available evidence informing its position on the appeals before the Planning Inspectorate.
Thank you, Mr. Livingston, for summarising the Council's position. I now will ask RiverOak if they wish to make an statement.
Thank you very much, sir. We do, and if I can ask for that to be distributed. Thank you very much, sir. Well, sir, the appeals before the inquiry are to be resolved, we respectfully suggest, by following the course set by statute, namely that the determination must be made in accordance with the development plan unless material considerations indicate otherwise. It's agreed that policy EC4 forms part of the development plan and applies to these proposals. That policy reserves the land and buildings at Manston Airport, upon which the appeal proposals are located, for airside development. Development proposals within the reserved land require specific justification to demonstrate that an airside location is essential. It is not disputed that the appeal proposals for non-aviation business and commercial uses do not require an airside location and are therefore in conflict with policy EC4. Planning permission should therefore be refused for these proposals unless there are material considerations that indicate otherwise, and we suggest that no such material considerations exist. So policy EC4 attracts full weight in these appeals. It is a policy necessary to preserve the integrity of the airport as an airport and to protect it from non-essential development. In seeking to do so, it is fully consistent with national policy. So these opening submissions address the proper approach to EC4, but before turning to that, it's necessary to consider the background to these appeals. Manston has been an airfield since the Great War. The local plan suggests 1918, but it appears that farmland at Manston was used for emergency landings from about 1915, and by the end of 1916 there were 2 units stationed at the Admiralty Aerodrome at Manston. By the outbreak of World War II in 1939, Manston was still an all-grass airfield. The runway was built in the 1940s. At the time it was the longest and widest in southern England, built to assist the safe landing of badly damaged aircraft returning from Europe. Civilian use of the airfield seems to have begun in the 1950s, 1960s, and in 1962 a part of the airfield was separated from the remainder, known as the Civilian Enclave, in which a wide range of civilian operations were carried out. In 1998 the Ministry of Defence sold what was then RAF Manston to the Wiggins Group, and Manston Airport then came into being. The more recent history of Manston and its ownership is set out in the evidence of George Yerrell. It can be seen from Mr Yerrell's evidence that there were specific reasons why past commercial endeavours of 2 previous owners at Manston Airport did not succeed. And more importantly, the evidence of Mr Yerrell, Mr Kane and Dr Dixon demonstrates that these past failures do not preclude the commercial success of the airport in the future. Rather, that past endeavours were misplaced, wrongly focused and underfinanced. In addition, Mr Yerrell's evidence also explains that Thanet District Council's failure to pursue a CPO for the airport land, with RiverOak as an indemnity partner, in order to ensure the use of the land as an airport, was through no fault of RiverOak or through a lack of endeavour on RiverOak's behalf. Mr Yerrell explains that RiverOak had offered to enter into a perfectly usual and acceptable indemnity agreement, which required RiverOak to do and provide what could be reasonably expected at that stage of the CPO process, and which completely protected the council against any financial liability if the CPO was confirmed. The opportunity for Thanet District Council to acquire the airport for airport use was there for it to take, but rather it chose not to do so. RiverOak has also made 4 offers to purchase the site from the appellant in order to bring it back into airport use, the last being made last year for a premium value of £10 million. In addition, the acquisition by the appellant and related companies of the airport land for £1, and the evidence provided that the owner refuses to use the airport land as an airport in the future because of a desire to promote 2,500 dwellings as part of a residential-led mixed-use scheme, is neither here nor there. The planning system works in the public interest and is not there to support private interests or aspirations which conflict with policies that protect the airport, so long as that remains a reasonable prospect, which clearly it does. The remainder of these opening submissions briefly address the key issues arising in the appeals in the following order. Firstly, whether the use of buildings for non-airport related use is acceptable, having regard to development plan and national policy, whether the proposals would compromise future aviation use of the airport, whether the proposals would create additional need for buildings in the countryside were airport operations to resume, and whether alternative employment land exists elsewhere. And then finally other matters, including the CPO and the development consent order as a way of reopening the airport. And so you'll see that those issues effectively reflect the issues that you yourself very helpfully identified back in February. or in the middle of February. Whether the use of buildings for non-airport related use is acceptable having regard to local and national policy. So the proposed non-airport related uses are contrary to policy EC4. The appellant's evidence suggests that policy EC4 should not be given full weight in the appeal decisions. Whilst Mr Alston advances various arguments as to why reduced weight should be placed on EC4, the main issue is whether or not there is a reasonable prospect of the airport reopening within the next planned period to 2031. And that's the way Mr Alston characterises his evidence. If there is a reasonable prospect of the airport reopening, which clearly there is, then it is essential that airport land is reserved for airport uses in the national interest, and policy EC4 be given full weight in the decision-making process. And so if I can just break off here, you obviously have heard Mr King's opening submissions, but in my submissions, sir, in characterising the issue as he does in paragraph 2, he misses the fundamental point that the key issue in this case, as set out by his witness, Mr Alston, is whether or not there is a reasonable prospect that this airport can be used as an airport. And it would seem from certainly paragraph 8 of Mr King's opening submission, and also from his indication that he has no questions for either Mr Kane or Dr Dixon, that clearly there is a concession by the appellants that there is a reasonable prospect that this airport can return to airport use. I agree with what he says in paragraph 13. It is not your function to reach a concluded view on whether the airport will return to airport use. Your function, sir, is to ask yourself the question whether there is, in the light of the evidence presented to you, and as a matter of planning judgment, a reasonable prospect that the airport can be used as an airport. And if the answer to that question is yes, and it seems that there is no dispute as to that, then policy EC4 attracts full weight, and these proposals should be refused. Just coming back then to my opening submissions at paragraph 14. RiverOak's proposals for Manston Airport is for a freight hub airport with some passenger services. The focus is, and always has been, as far as RiverOak is concerned, on freight. RiverOak's evidence provides an assessment of Manston's prospects as a freight-based airport and provides detailed empirical research data for a freight-based airport which underpins its business planning and detailed DCO work, and it seems that that evidence isn't disputed. In addition, RiverOak's sustained interest and considerable financial investment demonstrate that Manston Airport presents a very attractive, viable commercial proposition as such a freight-based airport. It's patently clear from RiverOak's evidence that the reopening of Manston Airport as a freight-based airport with passenger services is indeed a reasonable prospect, and it would seem that that is not challenged. RiverOak's evidence explains why the Avius Solutions report produced for the Council and relied upon by the appellant, although again, so you will note that Mr Kane's evidence, which explains why that report is misconceived, is not challenged, and which suggests that the airport is not viable, is not a sound document. It is apparent that officers and in turn the Council accepted at face value the Avius Solutions report. Insofar as that report informed the Council's decision not to defend these appeals and to change its emerging local plan policy away from protecting the airport and in favour of its residential development, it was wrong to do so. The Avius Solutions report was and remains untested. Its authors do not come to this inquiry to defend it, and indeed no aviation expert comes forward at this inquiry to defend it. No doubt, and in due course, it will be tested through the emerging local plan process and found wanting. And so again, if I can just break off here just to deal with the Council's opening statement. So you will see from the way that Mr Livingston sets out the Council's position that he does approach the matter in the way that we are suggesting it should be approached, by asking whether or not there is a reasonable prospect that this airport can be returned to airport use. And as a result of which that determines the weight to be attached to policy EC4. He relies upon the Aviation Solutions report in order to say, well, there isn't a reasonable prospect, and therefore policy EC4 attracts little weight. We say, for the reasons that we've set out in our evidence, that is wrong. The Aviation Solutions report is wrong. There is nobody here disputing that we are wrong to say that. And as a result of that, clearly there is a reasonable prospect, and full weight attracts to EC4. But insofar as the approach is concerned, so we say the Council's approach in asking itself the question as to whether or not there is a reasonable prospect is the correct approach, unlike the appellants who are suggesting an entirely different approach, which we say is simply just wrong. So coming back now then please to the opening statement of paragraph 17, it is clear from Mr Keynes, Dr Dixon's and Mr Yerrill's evidence that the Aviation Solutions report is not a sound piece of work. It was compiled under time pressure, it ignored RiverOak's plans for a freight-based airport, it declined to consider or look at RiverOak's business plan, it failed to take into account the level of investment that RiverOak plans, it wrongly assumes that the airport would not be able to generate appreciably more freight activity than it did when it closed. That assumption is in direct conflict with the evidence of Mr Kane and Dr Dixon, who forecast that Manston Airport can attract between 222,000 to 230,000 tonnes of freight by 2030. It fails to properly consider published expert reports by Transport for London and York Aviation that conclude that by 2050 there will be a lack of capacity for between 33 to 45,000 air freight movements in the London airport system, even with additional runway capacity and all the lost trade and value that that represents. Indeed, the Transport for London report specifically recognises that 14,000 of those air freight movements can be accommodated at Manston Airport. Certainly as far as freight is concerned, the Aviation Solutions report should not be relied upon, and nobody in front of this inquiry has called any expert evidence to support that. National aviation policy, which has largely been ignored in the appellant's evidence, is also important in this case. The aviation sector is a major contributor to the economy whose growth the government supports. It supports £52 billion worth towards UK GDP, supplies nearly 1 million jobs, and provides tradable goods through the UK airport system worth £140 billion. The aviation policy framework notes that in the short to medium term, a key priority for the government is to make better use of existing runway capacity at all UK airports. As Ms Shembry's evidence explains, because there is a realistic prospect of Manston Airport reopening, and in applying national policy, it is clear that full weight must be afforded to EC4 in reserving airport land for airport uses and in seeking to protect the integrity of Manston Airport. Policy EC4 is wholly consistent with national policy. And therefore, so we say the only reasonable conclusion is that the use of buildings 1 to 4 for non-airport related use is contrary to the development plan and unacceptable having regard to local and national policy, which policy EC4 is consistent with. Therefore, whether the proposals would compromise future aviation use of the airport. So we say the proposals would compromise the future aviation use of the airport, and there are 5 general points to make. First, if planning permission was granted in respect of any one of the appealed proposals, the effect would be to undermine the policy protection afforded to the airport land. It should not be necessary in relation to the reserved land, the subject of EC4, to examine proposals for non-aviation use minutely in order to see whether they might be able to coexist, or whether, and if so, to what extent they might comprise aviation use. The inspector will note that in relation to Endeavour House at Stansted Airport, planning permission for a temporary use of one floor of a building was refused on the basis that granting permission would undermine the consistent application of saved policy S4 of the Usselsheld local plan, which was the protective policy which applied at that airport. Secondly, use of the 4 appeal buildings as proposed in the appeals could not coexist with an operational Manston airport. The airport's master plan shows the intended use of the buildings, and that's explained in detail in Ms Shembry's evidence. Thirdly, any non-aviation use of the appeal buildings has the potential to reduce the security of the airport, which is a matter of obvious concern to the Civil Aviation Authority, the Licensing Authority. Even a temporary period, and 3 years is sought in respect of Building 1, would go well beyond the likely date of a decision on the intended development consent order and has the potential to cause delay in relation to CAA licensing. And just breaking off there again, in respect of the points that Mr King makes about effectively it's all rights to allow change of use pending the DCO. Well, the DCO on the timetable is likely to be confirmed at the end of 2018. So that's just over 18 months away. Fourthly, given the likelihood of disruptive activity arising from works immediately required to bring the airport back into operation, it is impractical to be introducing non-aviation occupiers onto airport land now. Again, introducing such uses give rise to the potential for delay to the reopening of the airport. And finally, the appellant's evidence points to the potential for a DCO to include provision for a compulsory purchase order, and suggests that if successful, compulsory acquisition of the airport site would enable vacant possession of the whole site to be secured, and that the reuse of some of the airfield buildings does not affect this position in any way. The appellant, perhaps naively, has failed to appreciate that the introduction of new occupiers onto land the subject of an imminent DCO application is only ever going to lead to additional complexity, reduced certainty and delay. Plainly, vacant possession can be secured, but introducing new uses now has the potential to have a material effect on timing and certainty in relation to timing. And we say that's precisely why, if there's a reasonable prospect that the airport can be put to airport use, full weight applies to EC4, which protects the integrity of the airport. Planning permission is sought for the change of use of Building 1 for a temporary period of 3 years for the general uses set out there. The use of Building 1, as proposed, could not coexist with an operational Manston airport. Ms Shembry produces the airport master plan, and from that it will be apparent that the use intended for Building 1 is as a maintenance, repair and overhaul facility. It's a building suitable for that purpose. It's designed in such a way that its doors open fully so as to allow aircraft to manoeuvre into the building, and it's of sufficient scale that it can accommodate aircraft. There is no other building at the airport at present which has the same or similar characteristics. And Mr Alston does not suggest that the use of Building 1 could coexist with an operational airport. Instead, he points out that permission is sought for a temporary period only, but we say that's for far, far too long in any event. Whether the proposals would create additional need for buildings in the countryside were airport operations to resume. If Manston Airport were to reopen, it will be apparent that non-aviation use of buildings 1 to 4 would not be acceptable. As things stand, a CPO in relation to the site as a whole would be needed, and in the end, vacant possession of those buildings would be secured. Without occupiers, that would be less complicated and timing more secure. It is highly unlikely that the buildings could be in a non-aviation use and coexist with an operational airport. And Mr King doesn't, I think, seriously suggest that it could in his opening. For that reason, it's unlikely that new buildings in the countryside would be needed as a result of aviation uses being displaced by non-aviation uses. However, if planning permission was granted and the buildings thereafter remained in non-aviation use, then clearly in that scenario, additional buildings would be required. And just briefly turn to whether alternative employment land exists elsewhere. So there is no shortage of available premises or available land, as Ms Shembry's evidence amply demonstrates. It follows that very little weight can be placed on the benefit of providing employment land at the appeal site, or the jobs that may come with that, as those jobs can be created in any event within the local area on employment land. And just pausing there, so insofar as your site visit is concerned, we may be asking that you across the road to Manston Business Park and see the amount of available employment land and premises that exist there. And then finally I turn to other matters, including the latest position in respect of possible compulsory purchase order or development consent order. RiverOak's evidence provides up-to-date information about the progress of its DCO application. RiverOak is on track to submit that application in the summer of 2017. There's a tightly prescribed timetable which follows thereafter, which should lead to a decision by the Secretary of State on the DCO before the end of 2018. Delays that occurred to the DCO process last year were largely due to the appellant's refusal to allow RiverOak and its consultants access to the airport to carry out the necessary survey work in order for it to prepare its environmental assessment for its DCO. That left RiverOak with no alternative but to make an application to the Planning Inspectorate under Section 53 of the Planning Act to require that access be provided. The Planning Inspectorate granted such access in December 2016, and in doing so recognised that RiverOak's proposal to use Manston Airport as an airport through the DCO process is a project of real substance, which is the test for granting of access against an owner's wishes under Section 53. And just pausing there, insofar as the appellants rely on any delay to the promotion of the DCO, that is largely a result of their own actions in refusing my clients access onto their land. And so finally, in conclusion, in due course, sir, we will be inviting you to dismiss these appeals on the basis that they are contrary to policy EC for the development plan, and there are no other material considerations that would justify a decision contrary to that policy. And those are my submissions. Thank you very much, sir.
Now, that concludes the opening statements of the party. I did mention that I would prefer to hear those who wish to make comments or make representations after the opening statements. What I'm proposing perhaps is maybe a short break now. It's 11:15, and just a short break, and then if we resume, we can hear the two speakers that indicated that they wanted to address the inquiry, and then we can get into the main evidence of the inquiry. How does that suit you, Mr. King and
Very well, sir. Yes, thank you.
Yeah. So I would suggest maybe we have a break of 10 minutes.